Welcome back, those of you in the audience who were here for our other two panels today, and for newcomers who arrived. Everything here is being recorded, so you can revisit at any time our Fulbright Ukraine YouTube channel, and you will find all of our discussions there. I would like to also remind that the deadline for our scholars program for Fulbright Ukraine for Ukrainian scholars is open still, so please apply if you are thinking about it. And on our website, we list all of our competitions, which begin again next summer, fall. That's sort of the kickoff season. So we're at the end of our application cycle now. Our panel ahead of us is entitled Legal Qualification of Atrocities and Human Rights Abuses in Ukraine. And I will not elaborate on the critical nature of all of these discussions, but certainly those of you who are in Ukraine now, I'm right now in Warsaw, normally would be based in Kyiv. We all are with you, thinking about you constantly. So if for any reason you need to leave, please prioritize your safety. I can't emphasize enough. That is number one. You can always come back to this discussion later, and that includes our speakers. So please, without further ado, I welcome Dr. Eppinger.
Great, thank you, Jessica. And thanks to all of you who are here today. I am pleased and honored to be moderating this panel, this discussion today. I'd like to first introduce our speakers and give a couple of words of introduction historically to the topic, and then turn it over to them for their presentations. We'll have presentations that will be 20 to 30 minutes. We give our speakers the authority to decide, and then after that we'll have questions and answers. And so if you have questions during the presentations, please feel free to write them in the chat, and then we will take questions at the end of the presentation. Our first speaker this morning is going to be Professor Myroslava Antonovych of the National University of Kyiv-Mohyla Academy of Kyiv, Ukraine, also affiliated with the Ukrainian Free University in Munich, Germany. And Professor Antonovych will be presenting on the topic of mental and material elements of genocide against the Ukrainian nation committed by Russia in Ukraine. And then our second speaker will be Oleksii Plotnikov, who is with the 10th of April Civic organization. He's the Geneva Call Representative Office in Ukraine. He's also affiliated with the Armed Forces of Ukraine in Kyiv, and the Justice for Atrocity Crimes. His topic that he will be speaking on is Justice for Atrocity Crimes in Ukrainian Courts, Challenges and Opportunities. And I wanted to just have a couple of words of introduction to our topic this morning, thinking historically. Our current jurisprudence in international law in the United States and around the world really is indebted to two foundational thinkers who had their formative legal training or legal experiences in Lviv. One of them, of course, is Raphaël Lemkin, who is known as the father of the concept of genocide, who received his law degree from the institution that is now called Ivan Franko University in Lviv. And the second person is Hirsch Lauterbach, who is a professor who started in Lviv and ended up as a professor of international law at Cambridge University. And I wanted to just read the germ of the idea of genocide being a crime under international law from Raphaël Lemkin. In his book, Axis Rule in Occupied Europe in 1943, he invented the term genocide by combining the word genos, which refers to race or people, and side, to kill, and he defined genocide. So I want to give his original germ of the idea because it's been refined in international law since then, but I thought it was useful to go back to origins. Raphaël Lemkin's original idea was that, generally speaking, I'm quoting here, genocide does not mean necessarily the immediate destruction of a nation, except, of course, when accomplished by mass killings of all members of a nation, he says this concept genocide is intended rather to signify a coordinated plan of different actions aimed at the destruction of essential foundations of the life of national groups, with the aim of annihilating the groups themselves. The objectives of such a plan would be, for example, the disintegration of the political and social institutions, of culture, language, national feelings, religion, and the economic existence of national groups, as well as the destruction of the personal security, liberty, health, dignity, and even the lives of individuals belonging to such groups. So he included in his concept of genocide originally, not just the mass extermination, not just Holocaust, of course, including Holocaust, but also disintegration of political and social institutions or attacks on the economic existence of a nation. And then Horst Lauterbach, I bring him into the discussion not only as someone who hails from Lviv, but he actually objected to Raphaël Lemkin's concept of genocide. And Lauterbach was influential. He influenced the American judge in the Nuremberg trials to include a charge of crimes against humanity. So you would think crimes against humanity and genocide must have a lot in common, but Lauterbach objected to Lemkin's concept of genocide, and his objection was based on the idea that he feared that the concept of genocide would be the root of pitting groups against each other, that itself would foster kind of intergroup hostility or conflict that people coming out of the World War II experience were trying to avoid repeating. And so it's that tension that lies at the base of our discussion today. It is thinking to the future about justice, about prevention, about redress, about reparation, and also to try to prevent repeating some of the atrocities and the conditions of possibility for atrocities. So with that, I turn it over to our distinguished speakers, and I'd like to turn it over first to Professor Antonovych.
Good morning, good afternoon, wherever you are from. When we met with Monica a couple of days ago in Chicago at the ASEES convention, I told Monica that I cannot speak about ongoing Russian genocide in Ukraine without tears. And we even joked that I would be crying half of my presentation. I would try not to, but it is really difficult to speak about genocide which your nation is surviving. It is difficult to realize that your neighbor falsified your history and presence and denies the right of your nation to exist. It's disappointing to read those claims and research which deny that what is going on in Ukraine is genocide. In my presentation, I would articulate arguments that genocide is being committed by Russia in the frame of Russian aggression against Ukraine. The 1948 UN Convention on Prevention and Punishment of the Crime of Genocide, Genocide Convention, defines the crime of genocide as any of the following acts committed with intent to destroy, in whole or in part, a national, ethnic, racial, or religious group as such, killing members of the group, causing serious bodily or mental harm to members of the group, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, imposing measures intended to prevent birth within the group, and forcibly transferring children of the group to another group. The Rome Statute of the International Criminal Court, ICC, includes the same definition of genocide. I would argue in my presentation that all enumerated genocidal acts are being committed by Russia in Ukraine since 24th February 2022, though this is not the first time in our history that Russian Empire, be it called Soviet Union or Russian Federation, is committing genocide of Ukrainians. As it is stated in Genocide Convention, genocide can be committed in time of peace or in time of war. The Holodomor genocide was committed in time of peace. Ongoing Russian genocide is being committed in time of Russian war against Ukraine. War crimes and crimes against humanity, which no doubt are also committed during this aggression, thus become instruments of committing genocide. In the Rome Statute of the ICC and in the document Elements of Crimes, which was developed by ICC and is used by ICC along with the Rome Statute as a source of law, ICC distinguishes between mental elements, mens rea, and material elements, actus reus, of the crimes, inter alia of a crime of genocide, over which ICC has jurisdiction. Mental elements of genocide include the specific intent, dolus specialis, and knowledge, while material elements include genocidal acts themselves. As it is stated in the Elements of Crimes, quote, a person shall be criminally responsible and liable for punishment for a crime within the jurisdiction of the court only if the material elements are committed with intent and knowledge. Where no reference is made in the Elements of Crimes to a mental element for any particular conduct, consequence, or circumstance listed, it is understood that the relevant mental element, that is intent, knowledge, or both, set out in Article 30 of the Rome Statute applies. According to Part 2 of Article 30 of the Rome Statute, a person has intent where, in relation to conduct, that person means to engage in the conduct, and B, in relation to a consequence, that person means to cause that consequence or is aware that it will occur in the ordinary course of events. In Part 3 of Article 30 of the Rome Statute, it is stated that for the purposes of this article, knowledge means awareness that a circumstance exists or a consequence will occur in the ordinary course of events. The facts and circumstances surrounding the ongoing Russian genocide in Ukraine point to the existence of such elements in this crime as the genocidal intent and knowing participation, and confirm the intent to destroy Ukrainians through killing, causing physical and mental harm, creating conditions of life calculated to destroy the Ukrainian nation, preventing birth rate, and transferring children from Ukrainian nation to Russian one. In the Elements of Crimes mentioned above, the components are singled out in each of the 5 genocidal acts. Thus, in genocide by killing, the following components are singled out. The perpetrator killed one or more persons. Second, such person or persons belonged to a particular national, ethnic, racial, or religious group. Third, the perpetrator intended to destroy in whole or in part that group. 4, the conduct took place in the context of a manifest pattern of similar conduct directed against that group, or was conduct that could itself effect such destruction. In such genocidal act as genocide by deliberately inflicting conditions of life calculated to bring about physical destruction of a group, the following elements are singled out by the International Criminal Court. First, the perpetrator inflicted certain conditions of life upon one or more persons, Second, such person or persons belonged to a particular national, ethnic, racial, or religious group. Third, the perpetrator intended to destroy in whole or in part that national, ethnic, racial, or religious group as such. Fourth, the conditions of life were calculated to bring about the physical destruction of that group in whole or in part. And fifth, the conduct took place in the context of a manifest pattern of similar conduct directed against that group, or was conduct that could itself bring about such destruction. Similarly, elements of genocide are singled out in other genocidal acts. All these elements might easily be identified in acts committed by Russian perpetrators in Ukraine, along with war crimes and crimes against humanity, or in other words, by those crimes. In the Raoul Wallenberg Center for Human Rights report called Independent Legal Analysis of the Russian Federation's Breaches of the Genocide Convention in Ukraine and the Duty to Prevent, which was issued in May 2022, it is stated, this report establishes reasonable grounds to conclude that Russia bears state responsibility for A, direct and public incitement to commit genocide, and B, a pattern of atrocities from which an inference of intent to destroy the Ukrainian national group in part can be drawn in breach of Article 3.c of and Article 2 of the Genocide Convention. This report has been produced with the contribution of and upon consultation with numerous independent experts, including most known experts in international law, international criminal law, such as Michael Scharf, David Sheffer, Marcy Shore, Irvin Kotler, historians Norman Neimer, Timothy Snyder, and many others. The report concludes that there is Russia's state-orchestrated incitement to genocide through denial of the existence of a Ukrainian identity, accusation in a mirror, denazification and dehumanization, construction of Ukrainians as an existential threat, conditioning the Russian audience to commit or condone atrocities. Public speeches of President Putin and his henchmen, in which they deny that Ukrainians constitute a nation, are well known. Thus, in his televised address to the nation on 22nd February 2022, Putin explicitly stated that Ukraine was an integral part of Russia, Russia's own history, culture, spiritual space. The intent to destroy the Ukrainian nation could be also inferred from other numerous speeches of Putin, Medvedev, Duma deputies, other politicians, religious figures, journalists, that constitute the general political doctrine which gave rise to the acts that might be qualified as genocide. Those statements might themselves be qualified as incitement to commit genocide by Russian military under Article 3 of the Genocide Convention, as mentioned above. I would remind you that on the 24th February 2022, there should have started final solution of the Ukrainian question in the course of a brief up to 3-day special military operation as planned by Russia. The phrasing final solution of the question was used by Hitler in the Second World War in relation to Jews, which was qualified as genocide of the Jewish people, the Holocaust. This very phrasing was used in the article by Timofey Sergeytsev, What Russia Should Do with Ukraine, the manifesto, the map of Russian genocide against the Ukrainian nation, published by Russian state news agency RIA Novosti, with clearly genocidal narrative, formulating the idea of destroying the Ukrainian nation. But even taking aside this article, which Russian Minister for Foreign Affairs Lavrov called a private view of the author, as if anything could have been published in state news agency without approval by political leadership, there are numerous other proofs of the intent of the Russian political and military leadership to commit genocide against the Ukrainian nation. As Volodymyr Sheluhin rightly states, quote, "This ideological framing does not see Ukrainians as a nation. According to this narrative, they have no right to their own language, culture, or state. It is misleading to think about this war as an armed struggle for territories, like many wars of the 19th century. In reality, this war is about identity and the world order. The Russian Federation is not willing to accept the existence of Ukraine and Ukrainian identity, just as much as it is not willing to accept liberal democracy, tolerance, and free speech. What is more, as it is stated in the elements of crimes, with respect to mental elements associated with elements involving value judgment, such as those using the terms inhumane or severe, it is not necessary that the perpetrator personally completed a particular value judgment, unless otherwise indicated. In addition, the report of the Raoul Wallenberg Center conclusively establishes genocidal intent, not only incitement to genocide as a separate crime, but also genocidal intent, which has been identified as the key element of genocide in Genocide Convention, Rome Statute, elements of crimes, and other statutes of ad hoc tribunals. What distinguishes genocide from other crimes is the intent to destroy, in whole or in part, a protected group as such. This intent might be attributed to a state through evidence of a general plan derived from official statements, documents, or policy, or can be inferred from a systematic pattern of atrocities targeting the protected group. Such statements concerning inference of intent were formulated by ICTY, International Criminal Tribunal for Yugoslavia, ICTY, Rwandan Tribunal, ICTR, and ICC. Thus, it was stated in Akayesu case of the ICTR that intent may be inferred from the following factors: the scale of atrocities committed, the general nature of the atrocities committed, the fact of deliberately or systematically targeting victims on account of their membership of a particular group, the general political doctrine which gave rise to the acts, the repetition of destructive and discriminatory acts, and others. In Kyiv-Mohyla and Truzindana case, ICTR trial chamber stated that as intent might be difficult to determine, the perpetrator's actions, including circumstantial evidence, however, may provide sufficient evidence of intent, and that intent can be inferred either from words or deeds, or may be demonstrated by a pattern of purposeful action. As it is stated in the Raoul Wallenberg Center's report, quote, "The 5 genocidal acts, killing, causing serious harm, deliberately inflicting physical, destructive conditions of life, imposing birth prevention measures, and forcibly transferring children to another group, can also point towards genocidal intent when viewed in their totality." One of the arguments of those who deny ongoing Russian genocide in Ukraine is that there is no genocidal plan. However, on the one hand, ICTY ruled in several cases that the existence of a plan or policy is not a legal ingredient of the crime of genocide. The ICTR also found in Kyiv-Mohyla and Truzindana case that a specific plan to destroy does not constitute an element of genocide, although it would appear that it is not easy to carry out a genocide without such a plan or organization. On the other hand, as stated in the report, a general plan to destroy the Ukrainian national group in part may be demonstrated by the incitement to genocide driving the current invasion, or by the striking patterns or methods of atrocities suggesting military policy. Authors of this report state that this genocidal pattern of destruction targeting Ukrainians is well known and includes A. Mass killings. Investigations have determined that Russian forces have rounded up Ukrainian civilians for mass executions across occupied territory, marked by a pattern of common killing methods, hands tied, tortured, and shot in the head at close range. The well-documented Bucha massacre may indicate consistent tactics employed by Russian forces across currently controlled areas are rapidly expanding, as documented by investigators and satellite imagery, though the full extent of the killing will not be known until access to sites controlled by Russian forces is secure. This pattern of destruction also includes deliberate attacks on shelters, evacuation routes, and humanitarian corridors. Russian forces are systematically attacking shelters and evacuation routes with precision, indicating military policy. Killing and trapping civilians is besieged or conflict areas. Indiscriminate bombardment of residential area is another proof of such behavior, such atrocities. Russian forces have extensively and inherently indiscriminate weapons with wide area effect or cluster munitions targeting densely populated areas in at least 8 of Ukraine's oblasts. Let me remind you that it was May 2022 when the report was issued. That was the situation on that time. Nowadays, all oblast provinces, regions of Ukraine are being targeted. Russian military sieges, deliberate and systematic infliction of life-threatening conditions, while bombarding Ukrainians in besieged areas from within and without. Russian forces have simultaneously and deliberately inflicted life-threatening conditions on them, among which destruction of vital infrastructure. Russian forces follow a similar pattern in besieging Ukrainian cities, first striking water, power, and communication sources, and further targeting medical facilities, grain warehouses, and aid distribution centers, suggesting a military strategy and policy of deliberately inflicting fatal conditions on Ukrainians. These coordinated actions by the Russian military to deprive Ukrainians of basic necessities and trap them under these destructive conditions tends to demonstrate that sieges are calculated to bring about their physical destruction. Another proof, attacks on healthcare. As of May 25th, as it is stated in the report, the World Health Organization has documented 248 attacks on Ukraine's healthcare system. Destruction of and seizure of necessities, humanitarian aid, and grain. Russian forces have destroyed and seized vast stores of grain, including expropriating hundreds of thousands of tons to Russia, and repeatedly blocked or seized humanitarian aid of workers seeking to evacuate civilians, using starvation as a weapon of war. And other sites of life-threatening conditions. Russian forces have held Ukrainian civilians at other sites where they are deprived of basic necessities, at times leading to more immediate deaths by suffocation or starvation. Genocidal pattern of destruction targeting Ukrainians also include rape and sexual violence. Reports of sexual violence and rape in Russian-occupied areas of Ukraine suggested a widespread and systematic pattern, including gang rape, rape in homes or shelters, rape of parents in front of children, and vice versa. Possible transfer of Ukrainians, which we have already heard about in the previous panel. Russia has reported the relocation of over 1 million people from Ukraine to Russia since the invasion began, including over 180,000 children. Refugees and officials have reported being transferred by force or threat of force. According to Ukrainian officials, Russian legislation is being reformed to expedite the adoption of children from the Donbass, while Ukrainian children forcibly sent to Russia are forced to take Russian classes. The forcible transfer of Ukrainian children to Russia is a genocidal act under Article 2.e of the Genocide Convention. As I have already mentioned, this report of Raoul Wallenberg Center on Human Rights has been issued in May 2002. And one of the conclusions is that there exists intent to destroy the Ukrainian national group in part. This is the conclusion in this report. However, since then, missile attacks of 80 to 100 missiles all at once on vitally important infrastructural objects in October 2022 all over Ukraine, in all oblast provinces of Ukraine, testify that there is intent to destroy Ukrainian nation in whole. Liberated since May 2022, Kharkiv region, part of Kherson region, and the city of Kherson, some villages in Donetsk and Luhansk region, evidenced new mass executions, torture, rape, and other genocidal acts against thousands of civilians. Having analyzed in detail the genocidal intent and the genocidal pattern of destruction targeting Ukraine, the authors of this report come to the conclusion about the existence of a serious risk of genocide, triggering the legal duty of all states to prevent genocide under Article 1 of the Genocide Convention. Unfortunately, it became impossible to prevent genocide, which was already ongoing since 24 February 2022. Though the language of Russian political and military leaders changed since then, and they do not longer speak about denazification, dehumanization of Ukrainians, their genocidal destruction of the Ukrainian nation continues. The incitement to commit genocide, which constitutes a separate crime under the Genocide Convention, which drove the invasion, and the genocidal intent, which is the key element of a crime of genocide, are clearly established. The genocidal acts committed with intent to destroy the Ukrainian nation form a pattern of genocidal destruction. The main task is now to hold those responsible, those guilty of the incitement to commit genocide and of committing the crime of genocide accountable. And I think my colleague would speak about justice concerning this genocide. Thank you for attention.
Thank you, Professor Antonovych, for this powerful intervention. And now I'd like to turn to Dr. Plotnikov.
So, good afternoon, everyone, or good morning, depending on the place where you are. I would like to thank all the distinguished speakers for their presentations. I was impressed to listen to them today, and I'm sorry that I couldn't join yesterday. And as was mentioned by Jessica, I am now with the armed forces, but unfortunately not in Kyiv. I am now kind of surrounded by the beautiful Ukrainian countryside. And that's why I apologize in advance for possible unstable internet connection. However, let's hope that everything goes well. And now let me please turn on my presentation. Yeah, here we go. Can everyone see the presentation? Is this okay?
It's good.
Okay, thank you. So this presentation is based largely on the research which I did together with UNDP in Ukraine back in late 2021, which is quite a long time from now. And a lot of things happened since that. However, its conclusions are still applicable because the core idea of this research was to enhance the capacity of the Ukrainian courts in prosecuting atrocity crimes committed during the armed conflict. And this remains applicable both to the conflict that we had before 24th February 2022 and after 24th February 2022. And I will concentrate on certain practical aspects of enhancing the capacity of the Ukrainian courts. And I would like to start with the definition of atrocity crimes, which are defined by the United Nations as international crimes of genocide, crimes against humanity, and war crimes. So this definition does not encompass aggression, which is the fourth core international crime. And, they concentrate on crimes which inflict sufferings to the people. And what is interesting about those crimes is that you cannot commit an atrocity crime alone. Even things like mass murders or, I don't know, school shootings that are committed by one person and that leads to the death of many people or suffering of many people are not considered as atrocity crimes. So war crimes, crimes against humanity, and genocide are committed normally by an organized group of people. And even though crimes like war crimes can in theory be committed by one person, they are always committed in certain context, which is created by a group. And this is most true for genocide, which is always committed collectively by a state or highly organized group. And even if one person commits a crime which is based on racial hatred or hate towards a certain ethnic group, it would not be considered a genocide. This can possibly be considered a hate crime. However, genocide is always a collective action. And if you look at the definition of genocide, which was so brilliantly described by Professor Antonovych, you will find out that neither of these actions can ever be committed by just one person. And speaking of genocide, we come across the problem of responsibility of top perpetrators and ordinary perpetrators. The difference between top perpetrators and ordinary perpetrators is that the top perpetrators always bear the greatest share of responsibility for genocide because they are those who architect genocide, who design genocide, who give orders, but they are those who normally do not commit genocidal actions themselves. So they are not those who commit murders, they are not those who take children from one ethnic group to another, and they do not commit any actions that are associated with genocide themselves. They need tools that are other people who are inspired or incited or forced by them to act in a manner that leads to genocide itself. And when we're talking about prosecuting the perpetrators of genocide and perpetrators of other atrocity crimes, such prosecutions are normally associated with the trials of the leaders of genocide, those who did not commit genocide themselves. And here I took from our presentations the examples of the trial at Nuremberg. You can see Hermann Göring, who was the top Nazi official.
I'm wondering if you might be wanting to advance your slides, because we're seeing just the title slide, and I think your slides would richly.
Sorry,
It's okay.
something
It's
went
okay.
wrong. Yes,
I'm sorry.
I
I'm sorry to
changed at least
interrupt. I
3
just
or
wanted
4
to let
slides
you.
already.
Yeah.
So can you see them now?
We see the slides, but we only see the title slide. So
Can
if
you see the second slide now?
no, the largest slide
I'm
is still the title.
sorry, something went wrong.
Yes. Now we see the second slide.
Yeah, you can
Yeah.
see the second slide now, yes?
Correct. So I apologize for interrupting. I just thought your slides
Yeah.
are so rich. I wanted to make sure they could be
No,
seen.
no problem. Can you see the second slide now?
Yes.
Which is atrocity crimes, 3 legally defined international crimes that are genocide, crimes against humanity, and war crimes.
Yes.
So here is the first slide that you were expected to see at this moment. And here you can see the prosecution of the top perpetrators of Nazi crimes, which is, I think it's Hermann Göring, of crimes in Yugoslavia, crimes in Rwanda, and you can see the International Criminal Court.
Sorry,
And,
we're still on slide 2.
Sorry?
We're still on the second slide.
No. It's a mess. Can you see the first slide now?
Yes. Yes. Now we're on 4th slide. Okay, thank you. Sorry about that.
Okay, so I think you can see the entire PowerPoint here, which is an awful outdated program, but I used it. Well, okay, let's proceed with this. So if you ask an average person of whom we're going to prosecute for genocide in Ukraine, the response would normally be Putin, and possibly we're going to prosecute Putin and some other top perpetrators. Maybe some people would name Russian top military leadership, or top speakers who incited genocide in Ukraine. However, those people are very visible. And the problem with prosecution of top officials is to get those top officials. However, there is another group of people who we need to prosecute, which are ordinary perpetrators. I will try to switch the slides now. Let's look at. Yeah, does it work? Can you see this fifth slide? Okay, perfect. So like 99% of perpetrators of genocide and other atrocity crimes are not top officials. They are those who commit genocidal actions themselves as a part of a group or atrocity crimes. And we must remember that genocide is always accompanied by other atrocity crimes like crimes against humanity and war crimes. And sometimes this may be a tricky task for the legalistically thinking people to distinguish between genocide itself and war crimes and crimes against humanity committed in the context of genocide, and whether a particular murder, rape, or any other violent action was a part of genocide, or was it another crime, another atrocity crime like crime against humanity or a war crime. However, the problem with one perpetrators is that they always expect to hide themselves in a shadow. They always expect that their names are not going to be revealed and they are not going to be tried for that what they've committed. And there is a lot of historical evidence that proves that very often their expectations are not in vain, and many perpetrators of atrocity crimes committed in the context of genocide did escape responsibility. And the problem which international law and domestic criminal law encounters here is the problem of impunity. How can we avoid impunity for genocide and other atrocity crimes? And the only answer is that we have to find and prosecute all those who were not only top officials, but who were also ordinary perpetrators of atrocity crimes. And this may be a tricky task because, as I mentioned, atrocity crimes committed by large groups, large and organized groups, and getting every perpetrator to justice may take decades. And another problem here is that international courts simply don't have a capacity to prosecute all those responsible for atrocity crimes. If you think about, say, International Criminal Court simply lacks the budget, it lacks judges, it lacks the opportunity to prosecute all those people. And that is why the task of prosecution of all perpetrators of atrocity crimes comes with the domestic courts. And once again, history suggests that 99% of perpetrators of atrocity crimes have been historically tried domestically. And this slide, you can see the example of Eichmann trial, which took place in Israel. Eichmann was not an ordinary perpetrator, but I selected this case because firstly, this was a domestic trial in Israel, and secondly, it took place years and decades after Eichmann's crimes have been committed. Another example here is my personally favorite, the Gagacha courts in Rwanda, which are based not only on international criminal law, but also on Rwandan original legal tradition, which proved to be quite successful for prosecution of those responsible for genocide in Rwanda. And the third example is that old man trying to hide his face. This is a person called Otto D. We don't know his family name. And he was said to be the last Holocaust perpetrator tried in Germany. This was a person who was accused and found guilty of being an accomplice of Holocaust during World War II. That person was like around 93 years old when he was found and eventually tried. And the rationale behind these trials is not even to bring the perpetrator to justice. This is a purpose. However, the main purpose here is to demonstrate that there is not going to be an impunity, is to demonstrate that atrocity crimes are never forgotten, and there are no terms in atrocity crimes, and the perpetrators are going to be brought to justice for their lifetime. And nobody can expect to be forgotten and to hide in the shadow. And in Ukraine, there are no reasons to believe that in Ukraine things are going to be different. Of course, we have a lot of talks about an international trial for the perpetrators of genocide, and there is a lot of work being done by the Ukrainian diplomacy and Ukrainian lawyers to create a tribunal for Putin and top perpetrators. However, we cannot forget that 99% of the job is to be done by Ukrainian courts. And I'm sorry. And the question is whether the Ukrainian courts are ready for these trials, whether the Ukrainian courts are able to do the job trying the ordinary perpetrators of atrocity crimes. And the answer which we gave in the research which I mentioned is yes. The Ukrainian courts are in a very advantageous position to act as courts for atrocity crimes, including genocide, those committed in Ukraine. Of course, this is all comparative, but we compared the situation in which Ukrainian courts found themselves with the situation in Germany in 1945, in Yugoslavia in 1996, in Rwanda in 1995, and we found that Ukraine is possibly in the most advantageous position to try the perpetrators of atrocity crimes. And there are three reasons why the Ukrainian courts are in the best position. Number one is that Ukraine is a state with strong institutions. There's a lot of criticism about corruption in Ukraine or institutional blunders in Ukraine. However, compared to other cases, Ukraine has strong democratic institutions, and it is a well-established democratic state where We'll have a stable and well-functioning court system. We'll have a developed legislation which is already being advanced in order to ensure trials for atrocity crimes. And Ukraine has global support. Ukraine, in fact, now has all the legal resources and all the experience of the world for the trials in atrocity crimes. And this gives us enough reasons to hope that Ukrainian courts will be able to cope with this task. However, this does not mean that Ukrainian courts are ideal. And in the framework of the research which I mentioned, we found that Ukrainian courts are, of course, best placed to try most of the ordinary perpetrators. However, what they need are, well, we outlined 5 questions, but here I left 4 questions because one of them became sort of outdated in 2022. And the question number 1 is learning. Ukrainian judges want to prosecute the perpetrators of atrocity crimes. However, they often do not understand how to do this correctly, because Ukrainian judges receive training for prosecution of ordinary criminals within the legal system of Ukraine, but they lack understanding of how international law works. They lack understanding of how even to apply the legal norms of Ukrainian law for prosecution of the perpetrators of atrocity crimes. Question number 2 are court capacities, which is that the Ukrainian courts are already highly overloaded with the ordinary trials, like prosecution of ordinary crimes, and they simply lack the ability to try the perpetrators of atrocity crimes, because they lack judges, they lack trained staff, and they just need more people to prosecute atrocity crimes in the complicated proceedings. And the point which many of the judges whom we questioned frequently raised was that perhaps the court must be strengthened by qualified experts in special chambers who are going to be specializing in prosecution of atrocity crimes only. Of course, there is a technical question of equipment, because high-profile cases like the prosecution of atrocity crimes needs stronger technical support. This may include technical means for recording the proceedings. This may include the means for broadcasting the proceedings. This may include the means for closing the identity of the witnesses, and many other things which need improvements in the Ukrainian legal system. And number 4, which many of the judges frequently mentioned, was protection. Protection of the judges, protection of the victims against possible threats from the armed groups, from protection from political influences, protection from the threats that may be associated with the prosecution of atrocity crimes. Because if you think about a judge sitting in The Hague, that judge may feel relatively safe in their beautiful city. However, if you think about a judge sitting in Donetsk, well, once Donetsk is liberated from the Russian army, that judge may feel very, very unsafe in the environment in which he or she will find themselves while prosecuting atrocity crimes on the ground. And that's why the protection of Ukrainian judges is to be enhanced. Another question is that Ukrainian courts and Ukrainian judges understand the importance of trials addressing certain very special aspects that are associated with atrocity crimes and genocide. And out of those aspects, we outlined the trials involving victims and perpetrators of sexual violence, cases where we're going to have child victims, which are not going to be infrequent, and cases involving vulnerable groups. And all that room for improvement that we described is especially important for cases involving such victims, and because The trials concerning such very special aspects may be complicated, and the victims may find themselves in a very vulnerable situation while standing in these trials. Because of underrepresentation and because of social stigmas associated with the crimes committed against those people. This is especially true taking into account the number of reports about sexual crimes committed in this conflict. And here we must take into account that sexual crimes are always underreported in any legal system. And in the context of an armed conflict, sexual crimes become especially underreported, and according to certain esteems by the human rights protector groups, we know like 1% of what has actually happened on the occupied territories. This is important in the cases concerning the child victims because, as was mentioned by Professor Antonovych, and other speakers, one of the aspects of genocide is forced transfer of children from one group to another. And this may be especially complicated to bring charges against the perpetrators of crimes against children, because those charges must be based largely on the testimonies given by children. And having a testimony from a child requires high retention and greater care from the court and from the social institutions. And even bringing those children to the court may be a complicated task. And of course, we're talking here about the vulnerable groups like ethnic minorities, like people with disabilities, who are one of the most underrepresented victims in any court, in any group of crimes, and who may find it especially challenging to come to the court and to testify and to explain the situation that happened with them. And this concerns not only the possibility, their readiness to testify, but also even the technical ability to testify available to these groups. And I would like to proceed with the experiences of the Ukrainian courts in trials that involve atrocity crimes. And this experience proved to be, on the one hand, it proved to be successful because the Ukrainian courts demonstrated readiness to try the perpetrators of atrocity crimes. But on the other hand, from the legal point of view, if you ask like any international lawyer like me whether they like those trials or not, the answer will be no. There is a lot of blunders associated with those trials. And here I outline three problems with the first experience of trials of atrocity crimes in the Ukrainian courts. Number one is that Ukrainian judges apply the law on atrocity crimes technically and in accordance with then, not very applicable legal definitions given in Criminal Code of Ukraine. One of the examples of such application are the terrorism charges, which are brought against actually combatants who are fighting on the side of the Russian-backed separatists. Well, we can call them Russian-backed separatists, you can call them members of armed groups operating in Ukraine, but normally those responsible for nothing else but just fighting against Ukraine are tried as terrorists because they are considered as members of terrorist groups. And you ask a question why there is a problem with charging the members of pro-Russian armed groups as terrorists. The problem here is that such charges do not take into account the nature of the armed conflict, and they do not take into account the fact that Ukraine is actually not fighting a terrorist group. It is fighting a country that operates through its subordinates in Ukraine, and charging the members of the pro-Russian armed group terrorists as terrorists is simply inaccurate. This may seem applicable in a case of an active fighter, but there are cases of like female cooks who simply joined those armed groups because of their internal beliefs and because of their political beliefs, and who have been prosecuted by Ukrainian courts as terrorists. I have no evidence as of the moment whether such sentences have been challenged before international courts, but if they are challenged before international courts, Ukraine is going to be in trouble. Here, I do not mean that Ukraine may not try members of the pro-Russian armed groups as terrorists. However, what I mean here is that the charges are to be more accurate and they are to correspond to higher international standards. In order to stand the international criticisms that are likely to be faced by those trials. The second example is something called the Shishimarin case. You may have heard of Shishimarin, who was just an ordinary Russian soldier, and judging from the reports of the advocates who participated in these proceedings, this was not the smartest person in the world. Who was in Bucha in March 2022, I'm sorry, and he shot a person because his commander himself ordered. Well, they believe that the person was a Ukrainian spy because that person was talking via a mobile phone, and Shishimarin was given an order to shoot that person, and he did. He was captured by the Ukrainian armed forces and he was tried. But the problem with this trial was that, number one, he was tried for an ordinary murder. So the context of armed conflict was not taken into account by the court of first instance. And the second problem here is the question of command responsibility. Well, if Shishimarin is guilty of homicide, whether his commander is guilty of homicide because he ordered him to kill a Ukrainian civilian. I'm afraid that we're not going to have a response to this question because that commander was exchanged as a part of the process of prisoner exchange. So an ordinary soldier got his life sentence, which was later replaced by the Court of Appeals with a 15-year sentence, but his commander is still at large. And the Ukrainian court simply did not even mention the important doctrines of international criminal law, like the command responsibility, when the court tried Shishimarin. And this process could possibly meet the standards of the Ukrainian legal system. It clearly does not meet the standards of international criminal law system. And it is highly likely that Ukraine is going to have a trouble with Shishimarin's case in international courts. And the problem number three is in absentia trials. International criminal law does not directly prohibit in absentia trials, but they are to correspond to certain very high standards in order to be considered fully legal under the international definition of in absentia trials, and the Ukrainian courts are not always able to meet those high standards of in absentia trials. And once again, this is not to assert that those prosecuted were not guilty of those charges they were charged with, but this is to bring the attention to the procedural question, which are likely to cause troubles to Ukraine and which are likely to cast a shadow on those prosecutions. And another very complicated aspect with domestic trials of prosecutors of atrocity crimes is that those trials are to be equally just for both parties. And here we come across the question of whether the Ukrainian courts are to try the Ukrainian soldiers for atrocity crimes committed during an armed conflict. We don't have evidence that Ukraine somehow committed genocide in this conflict. However, no army can fight with absolutely clean hands, and any army reflects the society which sent this army to the war, and no society is ever free of criminals, no society is ever free of individuals who consider war to be just an opportunity for personal enrichment or for satisfying their dark desires. And the famous example of such a trial was the so-called Tornado trial. Well, this story started when a group of people known as the Shakhtar's Battalion already back in 2014 decided that either have a gun, they can do anything, and they were involved in crimes like kidnapping, rape, and murder of civilians. They were fighting on the Ukrainian side, and what is good for Ukraine is that Ukraine did prosecute the commanders of this Shakhtar's battalion, which later became known as Tornado Battalion. But on the other hand, many of, well, there are reasons to believe that many of the actual perpetrators did escape justice because of political pressures. And these political pressures are going to be very active in case the Ukrainian courts will ever try to prosecute the Ukrainian soldiers for crimes committed in the armed conflict. Another problem here is possible trivialization of atrocity crimes committed, well, possibly committed by Ukrainian soldiers. I personally came across a case which I believe to be remarkable. The situation was that a Ukrainian soldier who was just guarding his post on the road, he had an argument with a group, with two people who were just traveling by car, and he disliked something about them, and he just took his gun and shot them. So he killed two people, and he was prosecuted. He was prosecuted for double murder, and he got his sentence. But once again, this was not tried as a crime, although the entire context of his conduct revealed that this was a crime. However, he was tried for commission of an ordinary crime as if it was committed outside of the context of the armed conflict. And the Ukrainian courts are not ready to try either the Ukrainian or the Russian or pro-Russian perpetrators of crimes committed in the context of the armed conflict. And when we're thinking about the development of the Ukrainian legal system for the prosecution of perpetrators of atrocity crimes, two questions come. Number one is whether it is indeed necessary to improve the legal system to try the perpetrators of war crimes against humanity and genocide, and whether the Ukrainian courts will be able to do this job. According to the outcomes of our research, the judges of Ukraine do estimate that the Ukrainian legal system will be capable of judging the perpetrators of atrocity crimes. However, it needs international support, it needs international consultations, and most importantly, this is going to be a long process. So the second question, which stems from the first question, is how long it will take to prosecute the perpetrators of international crimes, and how long will the Ukrainian legal system will be charged with the task of prosecution of perpetrators of atrocity crimes. And the answer is for a lifetime. It's for our lifetime, and possibly for the lifetime of the next generation. It was not by chance that I mentioned that German old man known as Otto D at the beginning, because he was tried for being an accomplice of Holocaust almost 80 years after he committed his crime. And the Ukrainian legal system is to be ready to exist in this regime of trial of perpetrators of atrocity crime for decades. And it must be able to keep the pace of prosecuting the perpetrators of atrocity crimes for decades. But we must take into account that this process is going to develop over time. And over time, the purpose of bringing a concrete perpetrator to justice is going to reduce, and we are going to see the rise of two other topics, such as truth-telling and collective memory. Because the task of the courts trying atrocity crimes and most importantly genocide is not only to bring justice to the perpetrators, but also to give justice to victims and to create a narrative that is going to be describing that what has happened in a particular country and at a particular time during the commission of atrocity crimes. And they are going to play an important role in the formation of that narrative based on the truth that the courts are going to discover. And finally, the courts are going to form our collective memory about that event. And here, I would like to complete with a quote of a Croatian lawyer I spoke to in 2007 during a conference in 2017, who said that we started prosecuting war crimes 4 years after the conflict. I wish we started prosecuting them 4 years before the conflict. And Ukraine here now is in a favorable position because we started thinking about prosecution of atrocity crimes. Well, not before the conflict. I wish we started before the conflict, but we started thinking about it in the first days of the conflict. And that's why I do believe that the Ukrainian legal system will be capable of prosecuting genocide and other atrocity crimes. However, it will take a lot of effort, a lot of time, and it will require a lot of international support. So I thank you for your attention. And if there are any questions, I will be happy to answer. Thank you.
Thank you, Dr. Plotnikov, for this powerful presentation. We're now ready for questions, and I'd like to start. I have a few myself, but I will refer to the first question that Dr. Plotnikov has for Professor Antonovych. He asks, what is your opinion about an argument that's frequently raised by the Russian side, that is that there are a lot of ethnic Ukrainians who have supported the aggression and actions of Russia in Ukraine. Some of them are members of pro-Russian armed groups and even occupy certain positions in Russian administrations. How can this argument influence the qualification of Russia's actions as genocide?
Thank you, Oleksii. So my answer would be that there has always been collaborators in any war. There are, of course, collaborators in this war. They are not that many. 3/4 of population in occupied territories have left, displaced persons in Ukraine. And among those who left, really, majority stood with blue and yellow flags in front of Russian tanks. And we see now how they meet Ukrainian army. This is the main argument against, and this is understood by Russian propaganda, even by Solovyov and the like, very well. So they see how Ukrainians in occupied territory meet Ukrainian army when Ukrainian army liberates the territory. Many pro-Russian politicians now clearly stand in defense of Ukraine. Let me give you one example, Vilko, who used to be very pro-Russian. Now he is the leader of the territorial defense in Kryvyi Rih. And I can give you a lot of such examples when pro-Russian opposition in Ukrainian parliament is now strongly supported Ukrainian army, Ukrainian territorial defense, and so on. So I would not pay attention to this argument of Russia. We understand that Russia, of course, says that there is no genocide. What is more, they have accused Ukraine of genocide in Donbass. They have submitted a case to International Court of Justice saying that Ukraine, oh no, sorry, this is the Ukrainian case against Russia, in which we say that this accusation of Ukraine that we committed genocide in Donbass, which was actually the main argument of Russian special operation, that they started this operation because Ukraine is committing genocide in Donbass, and Ukraine submitted this case to the International Court of Justice, accusing Russia of misinterpretation, misuse of the Genocide Convention, and we accuse Russia in committing genocide. So I think that we should not pay any attention to Russians' arguments at all. Thank you.
Thank you very much. I see a question from Maria Shimchishin.
Okay, good evening. Do you hear me?
Yes.
Okay, so thank you for both presentations and very inspiring speeches. And maybe I have a question to both, or just maybe it's not a question, but a reflection. So the first thing is that Russian Empire and Soviet Empire, they were never punished for all those crimes before in their history, yes, that they made against either the Ukrainian nation or other nations, yes. And this thing that they were never punished for these crimes, so it allows them to repeat those crimes, and they are doing this now. So it becomes like a pattern. So it is repeated again and again, and they know that in the end they will somehow escape from the punishment, from justice, whatever. And as during the first session, we've already had, yes, that there is no perspective also in this case, yes, that because there are some like preconditions for this implementing this justice, let's say, or this punishment, yes, as the collapse of the empire or the occupation of the empire, whatever. And so there are no such prospects just now, yes. And so, and this leads to the next problem, which is this, as you, Oleksii, mentioned, that these crimes, they are collective crimes, yes, and the responsibility also should be collective. So how is it possible, or how do you imagine it is possible that all Russians will admit, yes, that they are responsible for not only their government, yes, or Putin, but they are all responsible for what is going on now in Ukraine. So how how is it possible from your point of view? Thank you.
So how about
Professor Antonovych will start.
Yeah, I might.
This very important question.
Yes, because when we speak about genocide, we should remember that there is collective intent and individual intent in the crime of genocide. Collective intent is this plan or policy which has been formulated by leaders of the state, and individual intent is intent of every perpetrator of the crime of genocide. And these leaders of the state, they should be held accountable, say, in international criminal court, but the perpetrators, ordinary perpetrators, and they would be, we understand, hundreds of thousands or tens of thousands, I don't know how many. So in every case, it should be proved that they acted with intent to destroy the Ukrainian national group, or at least they knew about the existence of such a plan and about the consequences which would be in the result of their actions. So that would be a long process of domestic cases, about which Oleksii has already mentioned, of cases of foreign jurisdictions, Actually, any state may hold them responsible under the universal jurisdiction for the crime of genocide. I cannot say that all Russian people would be accused of genocide against Ukrainians. Of course, this is not the case. The perpetrators of genocide would be tried. We do not speak about this guilt of Russians in general. Oleksii, you would like to continue?
I sure would. Thank you, Professor Antonovych. And I thank Maria for this very important, interesting question. I would respond to this question twofold. The first aspect is that this is exactly impunity that you are talking about. And the reason why this genocide became possible is, well, politically speaking and historically speaking, is that Russia has never learned a lesson from the past, that many nations already learned through their very different experiences, whether we're talking about the experience of Germany with that underwent denazification, or the experience of many Western nations which now undergo a process of decolonization of their thinking and understanding that crimes have been committed in the context of colonialism, and that they are responsible for those crimes even centuries after those crimes have been committed. I'm afraid that in Russia failed to learn this lesson. And this is a problem of Russia only. This is a problem of many countries that still needs to, well, I wouldn't say countries. I oppose any sort of collective blaming, collective shaming. There is always an individual responsibility, but this is not about responsibility in the sense of criminal law. This is rather about understanding of the lesson. And many communities in the world still, well, if we can think about such a thing as collective thinking and collective memory, they do not have a record in their collective memory that certain things can never be committed and certain things are to be avoided, and there are certain indicators that demonstrate that certain thing is going to happen and it must be avoided, and society must take certain effort to avoid that thing. And the reason why this has not happened with Russia, well, to a great extent with Ukraine as well, and as well as with any post-Soviet society, is that we did not have a trial of communism, and we never had something similar to Nuremberg on the crimes committed by the communist regime in Russia and in the post-Soviet space. And actions of the Russian Empire as a colonial state, and the actions of the Soviet Union as an authoritarian and totalitarian states were never evaluated from the legal point of view. So they were somehow considered philosophically, somehow considered historically, but never legally. And the second aspect here is that once again, I oppose any idea of collective guilt, because the guilt from the legal point of view is a very strict notion which is always associated with the personal actions and with personal intent. But there is still a collective responsibility which is not strictly speaking legal, but which is a part of culture, which is a part of the historical memory. And that's the reason why I mentioned historical memory and the influence of courts on the historical memory at the end of my presentation, which is a separate and extremely interesting topic. What Russia is lacking now and what it can possibly obtain from this conflict, the lesson that Russia can learn from this conflict, is to stem from the prosecution of the perpetrators of atrocity crimes committed in Ukraine. And well, I hope that once we're going to have a sort of Nuremberg trial for the crimes of the past. And that's, to me, this is the most important philosophical and historical reason why Ukraine must do its best to prosecute the perpetrators of international crimes and must do it perfectly legally. Because a perfectly legal trial can possibly destroy the impunity, and more importantly, it is capable of forming a collective memory that is going to prevent similar atrocities in the future. Sorry for being too lengthy, but this is a very big topic.
Right. There's another question in the chat that Dr. Plotnikov, you may have just answered, but the question in the chat is, do you agree that with Alexandra Matvichuk that a separate international tribunal will be needed to bring perpetrators to justice? And I'm assuming if we talk about a Nuremberg-style tribunal, one possible kind of tribunal would be for those extraordinary top perpetrators that you were describing, Dr. Plotnikov. But you may have just answered that in your previous answer, but if you want to add any thoughts, either one of you, on the possibility of a special tribunal?
If I may.
Sorry, Professor Antonovych.
Yeah, I might say a few words about that. So ICC has jurisdiction over crimes of genocide, war crimes, crimes against humanity. ICC against Russia, it has already a possibility to exercise its jurisdiction. What concerns crime of aggression, ICC cannot exercise this jurisdiction because Russia would never ratify the Rome Statute and amendments concerning aggression. So for the crime of aggression, we do need this special international tribunal. For other crimes, ICC would be enough. And what Oleksii has been talking about, the national courts, not only Ukrainian domestic courts, but domestic courts of other states as well. Thank you.
Thank you.
Let me please add something to this response. I fully agree with Professor Antonovych that the ICC can try the Russian top perpetrators. But one of the questions that we asked during our research back in 2021 was we were talking to Ukrainian judges and legal experts, and we had interviews with around 100 of them. And one of the questions that we asked is whether the perpetrators of international crimes and atrocity crimes are to be tried in the ICC, in Ukrainian courts, or we need a specialized internationalized court for Ukraine, and or possibly we can create special chambers following the example of Croatia, which created special chambers in its courts with international participation. And most of them, like 40%, which is relatively the majority, voted for special chambers in the Ukrainian courts that are going to be governed by Ukrainian law, but that are going to have a special expertise in application of international law to the perpetrators of international crimes. And the judge told us that, yes, we can prosecute them as judges, but we need expert support. And those chambers are to be formed out of a Ukrainian judge who is going to formally apply the law, and a group of Ukrainian and international experts that are going to advise the judge on how to apply international law, international criminal law in this particular case, and how to follow the strict international standards in the application of international law. And so the answer is very positive. We need a lot of international participation in prosecution of perpetrators of atrocity crimes, but this participation is to rely on the available resources. Of course, it would be very good to have an international trial for everyone, because this is a very high standard of legal expertise. But if you think about trying even 1,000 people in international courts, well, the international courts will not be capable of doing this. They can never do this. The ICC has a very limited budget. So here we are going to rely on international courts with some sort of international participation. And this is the way to avoid impunity, and avoiding impunity is the way to avoiding the repetition. Thank you.
Great. Thank you very much. I have a question for you, Dr. Plotnikov. I believe that you conducted this research under the auspices of a UNDP reporting process. Is that right?
Yes, that's right.
Is there a place that, can I put a search term in the chat where people could search to find this? Would it be 20?
I can send a link to our chat.
That would be great. Thank you. That would be very helpful.
The full version is in Ukrainian, but there is a shorter version English.
Great, and either one would be helpful.
But if you mention this, please take into account that this is a research on the conflict that we had in 2021,
right.
Not the one.
Clear. And also, that leads me to also say, we welcome questions in the chat, and you may put questions in English. You may also put them in Ukrainian or any other language that we could try to decipher. So, якщо ви бажаєте, будь ласка, пишіть вопроси в чаті. Okay. And please excuse my Ukrainian pronunciation. Right. I have a couple of questions, if I may. I have a technical question and a reflexive question for each of you. So my question for Professor Antonovych, my technical question, I'm thinking about something like the destruction of Mariupol, and you talked about other incidents of indiscriminate killing and destruction. And if the core of the crime of genocide is destruction of a group based on national, ethnic, religious, or some other affiliation, then if the core of the crime of genocide is discrimination, then does indiscriminate killing serve as evidence of genocide? Or is it a different crime of atrocity that's not genocide? That's my technical question for you. And then I have a reflexive question, but I'll let you respond to that one first.
So the key issue of the genocide, as I have already mentioned, is intent to destroy a nation, in our case, the national group. What are the methods? What are genocidal acts? You mentioned this one, indiscriminate shelling or indiscriminate killing as a genocidal act. If there is a genocidal intent, then that would be genocidal act to reach this intent, to implement this intent. I have no doubts that the intent was to destroy the Ukrainian national group. Russians view people in Ukraine as Ukrainian national group, no matter whether they speak Russian or English or Ukrainian, it doesn't matter. For them, we are Ukrainian national group, and they try to destroy us. Other mass atrocities, or mass attacks, if there is no intent to destroy the group, then that would be the methods, or then that would be mass attack or mass atrocity. Just this is what differentiates genocide from other mass atrocities.
It's interesting. There's going to be a lot of thinking for international law scholars to think about if the intent is to destroy people and the person holding that criminal intent is identifying the group based on a territory, then how do we distinguish destruction of a people from attack on a territory? That's going to be a question for the future, but I hear your answer. I have a second reflexive question for you, Professor Antonovych. From your experience, has this war, let's say the full-scale invasion since 2022, although you may go back to 2014. Has this war altered or informed your own personal feeling of identity with the group called Ukrainians, or what you observe of other Ukrainians' experience of what it means to be Ukrainian?
For me, it has not changed anything. I had this strong, very strong Ukrainian identity, as my parents are from Western Ukraine, though I was born in Kryvyi Rih, but they were from Western Ukraine. And what is going on in Ukraine now, in Eastern Ukraine and Southern Ukraine, they experienced in 1939, from 39 till 46. The same methods. So for me, I expected this. I knew that it would happen. Nothing new. I think that people in Southern Ukraine and in Eastern Ukraine now understand what it means to be Ukrainian, that they are killed because they are Ukrainians. They did nothing wrong. They are ordinary people. My doctor was killed at his back in Bucha, not in Bucha, in Warsaw. And then he was burnt. He was Russian speaking. I'm sure he has not quarreled with his perpetrators. They just killed him as no grounds to kill him. They killed him as an ordinary Ukrainian. So I think this people from Western, from Southern and Eastern Ukraine are now understanding deeply what it means to be Ukrainian, and they are destroyed because they are Ukrainian. This is what I think. Yeah.
There's something paradoxical to me in the intent behind genocide to destroy a group, if one of the effects is to make the group identity stronger. And I see that Dr. Plotnikov may have a follow-up question to that.
Yeah, I have a follow-up response, which is, well, mostly for our international friends attending this conference, because I'm going to talk about something very obvious for Ukrainians. But it's interesting that this war did shape the Ukrainian identity of a lot of people. Like, I'll know at least two Russian-speaking people from Sevastopol, which is considered to be a Russian stronghold in Crimea. One of them is now with the armed forces of Ukraine, and another one is actively working in the humanitarian sphere on the Ukrainian side, and they started associating themselves with Ukraine when this conflict began. And what I can see in the army, well, the army is considered to be a reflection of the society, as I said. And in the army, I can see people whom I would never think that they would somehow think politically. I never thought that those people could ever just think about their nationality. They were like absolutely international, modern guys, girls who just live their beautiful lives and had many views on Instagram. They are now absolutely Ukrainian, patriotic, and some of them are in the army, others are volunteering. And this conflict did strengthen the Ukrainian identity enormously. And I hate saying this, but this group conflict interaction does shape the identity of the group. And this is both good and bad, because on the one hand, the group becomes strong, but on the other hand, this opens the doors to many negative aspects of group interaction associated with the conflict. So it's a pity that a lot of Ukrainians found the Ukrainian identity as a result of opposition to Russia. And I think that their Ukrainian identity is in the process of formation, and I do hope that it will not be based only on the opposition, so that they will find some roots that will create a positive Ukrainian identity, not a negative one for them. Thank you.
And I promised a technical question to you, Dr. Plotnikov. So my technical question for you, based on your presentation, when you just distinguished between top perpetrators and ordinary perpetrators, I'm curious about during this, since February 24th, this current phase of the war, in liberated areas, there are reports of local people who are accused of collaborating under Russian occupation, just in the last 9 months of Russian occupation, accused of collaborating, of identifying their neighbors. So if someone, for example, was held or tortured, that the neighbors had identified them as having a family member who might serve in the armed forces or something like that. So what about criminal liability for local residents of villages and towns in Ukraine? What about criminal liability in these as ordinary perpetrators of local collaborators?
Do I understand you correctly? You are talking about those people who voluntarily helped the Russian occupiers, or those who were tortured to give some evidence about the others and who were forced to collaborate?
Let's say the ones who voluntarily, and I know that we have to take this with a giant grain of salt, because voluntarily under conditions of occupation, we can't assess voluntariness very freely, but someone who was never tortured, who was never detained, but who themselves told occupying forces which of their neighbors to detain or to question.
This is a very complicated question because, well, let's concentrate on something that I know, which is law. I'm not going to speak about any moral esteems, but from the legal point of view, this is a question of intent. And the question number one that I would ask here is whether a certain act was a genocidal act, or whether it was, well, possibly another atrocity crime, or maybe even just an ordinary crime. For ordinary crimes can theoretically be committed in the context of armed conflict ends. So it depends, like just looting or whatever. Well, let's take the situation of an act that was qualified as a part of genocide. So if we qualify a certain act as a genocidal act, the second question would be whether a particular person had a genocidal intent while committing a certain act. Because intents can very much differ. This collaboration, which led to an atrocity crime committed by others, was resulted from ethnical, racial, or other considerations which associated with genocide, yes, possibly the person can be an accomplice of a genocidal act. If not, if that person was motivated by, say, his well, certain material motives like looting or whatever, it is not going to be genocide. But this very much depends on the context, and this very much depends on the particular situation. So this has to be determined on the case-by-case basis. But the distinguishing criteria, I would name the intent.
Got it. It's been pointed out to me that we have exceeded our time. I was so engrossed in these fascinating presentations that it turns out that we have exceeded our time. So just as one final thought, I'm a legal scholar, but I'm also an anthropologist. And what I see from observing friends in Ukraine these days and friends internationally is that we all have very high expectations of law. We have accountability, justice, as you pointed out, Dr. Plotnikov, truth, historical memory. And my question as an anthropologist is, how much can law deliver on these expectations? We have so many expectations of legal rituals. And one of the questions that faces us, anyone who's part of our group today, who is a legal professional, the question is, can law deliver on our expectations? And what do we do with any disappointments? That's a question for the future after victory. I wish you all to stay very safe.
Let me please tell you something very briefly.
Please.
As a member of the armed forces, I have an opportunity to communicate a lot with the soldiers, with just like ordinary guys who were never lawyers, who never thought they will ever participate in anything political like war. And I can see that there is an extraordinary high demand for justice. And people ask me, as a lawyer, they ask me, what can we do to bring those people to justice? And because they don't believe in justice, they think about stupid things like, oh, find them all and kill them all and so forth. This is one of the, why can't I cut off the prisoners' ear because they did such awful things and so forth. And we need to give the people the understanding that their desire for justice is going to be satisfied. This is what the law must do. It must show that justice has had its way. Because if justice, a formal and legal justice and very persuasive justice, is not going to have its way, then we're going to have another group of atrocity crimes, and we are going to have a spiral of violence. We must stop that spiral. No, thank you.
Just a few sentences. So what Oleksii said is our expectations. I do have expectations that law would work in this case, but hundreds of years of genocides proved that though victims of genocides are counted in hundreds of millions, those who were punished are just only few. So I do not have great expectations, but I love the phrasing by Eugene Finkel, it seems to me, that genocide is too big a crime to be left to lawyers. So now we expect everybody's help, anthropologists, everybody, to help us to cope with this genocide and to come to terms with the past. Thank you.
The past, the present, and the future.
The future. Yeah.
Thank you both so much. I turn it back to Jessica. Thanks so much.
Yeah, thank you so much. I'm going to listen to this again and think more deeply through some of the technicalities. And just to echo again what Myroslava was saying about everyone, you know, this is an issue that sets a precedent. I mean, it's unprecedented alone that we can have a conversation about an investigation of a genocide as it's taking place. And I believe it is taking place. So conclusively, I think many of our speakers today and yesterday could reach a consensus by many different means and many different disciplines, anthropology, law, to support a future direction towards justice and a common recognition of that. And also, I think it's a civic identity that Ukraine is a nation, and it's also a place where many different nationalities have made their home recently and over the long term. And to be Ukrainian or Ukrainianness is also, you know, to go beyond just an ethnic identification in what maybe Putin is targeting. Because I know, even as an American with an American passport, to go into Ukraine, I'm more at risk because of my nationality and its alliance with Ukraine than I am with a bomb falling on me, perhaps. That there are these alliances and solidarities and assumptions that are made, I think, that are becoming more and more unifying, that we are all Ukrainian in the end if we admit to a 21st century genocide, and we you know, are all going to be impacted by the lessons that unfold out of this, as Oleksii Plotnikov mentioned, for generations. So and as someone raising a small child who speaks Ukrainian and English and different languages, I want to be able to explain to her this moment in decades to come. And certainly genocide is one of the unthinkable realities and phenomena that has been around since the Romans. And we are a thinking community at Fulbright, so thank you to all of you for helping the non-experts among us, myself included, to try to think the unthinkable. Thank you so much, and we will definitely be in touch again. So, and thank you to all of our audience members out there for your wonderful questions, comments, and participation here today.